everyone. I hope you are having a wonderful day. I am. It's the first day of not summer here in Florida. Look, we have sweaters. It's not hot. We're not sweating. It's so exciting. Best day ever. For real. Don't worry, it'll be 80 again tomorrow, but we're gonna bask in this moment. So, do you know that saying like this meeting could have been an email? This is the court version of that. Like this entire court case could have been summed up in 2 words. 3. Oops. I'm sorry. Basically, that's all I wanted was an acknowledgement. Like, hey, I screwed up. Never happen again. Sometimes I'm so guilty of this. When you're starting to explain something, you over-explain. And when you over-explain, you're giving way too many details. And some people like me do it because I want to give you all the information so you can make an informed decision. But other people do it when they're trying to circumvent the truth. I learned this from my therapist. It's called, and it's a mechanism of avoidance where you see it a lot in interrogations and things of that nature. When someone's asked a direct question, instead of answering that direct question, you get a whole word salad jambalaya casserole of letters and just gobbledygook of everything except what you were looking for. And that's because there's some kind of negative emotion attached to whatever that answer is. Interesting, right? Okay, so I'm not even going to give you a background on this case because the judge kind of breaks it down, what was missed. I just thought it was interesting to see the response because maybe some people, obviously some people are different, but when I get a letter home from the principal, from the boss, from the big dog, I'm gonna write that one down, exclamation point. The fact that people are blowing it off, kind of the priorities. And then yeah, you'll see. All right, let's go to court. Hey, look, that was me giving you way too much information when I could have made it shorter. Working on that. There's sticky notes on my computer.
And welcome to a hearing session of the 6th District Court of Appeals. My name is Dan Traver. I'm joined on the panel today by Judge Carrie Ann Wozniak and Judge Petra Brownlee. We're here today on case number 2024-0159, Henry Saman versus ASI Preferred Insurance Corporation. We are specifically here on a show cause order directed to counsel for the appellant, Mr. Saman. That's Melissa Giassi. Am I pronouncing your name correctly, ma'am?
Yes, Your Honor.
And I understand from your answer that you can hear me correctly. Mr. Bitar, you are counsel for ASI, correct, sir?
That is correct.
All right, welcome. Ms. Giassi, I would like to hear your response to the show cause order. I'm mindful of something that was filed to the e-portal last night around 6:30 last night. And because our deputy clerks don't work 24 hours a day, we were alerted to it this morning. And you can, when it's time for you to talk, you can absolutely talk and explain what you'd like to explain. You will have an opportunity to do that. I'd like to set the stage a little bit.
Sure.
This appeal began with a notice of appeal filed on January 23rd of this year, which is close to 11 months ago. You had signed the notice of appeal on behalf of your client. On March 26th of this year, we directed the parties to file confidential mediation statements and questionnaires. And on April 5th, without divulging the contents of what was included in those statements, Ms. Giassi signed both of those statements on behalf of Mr. Saman. We directed the parties we ordered the case to mediation on April 12th. This triggered an April 24th response deadline for the parties to file a response and to select a mediator. And on that date, Ms. Giassi signed and filed the response. On May 30th, we appointed the mediator, and this order triggered a 60-day deadline to complete mediation, which would have been July 29th of this year, approximately 4 months ago. On September 6th, the counsel for the appellee filed a request for briefing schedule. In it, he represented that the parties set the mediation for July 31st of 2024, but that Ms. Giassi canceled it on July 30th. I understand, although, that she did not allegedly call or write before this cancellation. She called the same day to apologize, and claimed a scheduling conflict. Appellee's counsel said that Ms. Giassi had not responded to repeated rescheduling requests since that time. On September 10th of this year, we ordered a counsel for the appellant. At that point, it was Ms. Giassi and Ms. Berger to respond to that request for briefing schedule. And specifically, we wanted counsel to address the factual allegations that I just recited that were in the appellee's request for briefing schedule. That response was not filed. On September 23rd, we issued an order to show cause as to why we should not impose sanctions against Ms. Giassi and Ms. Berger for failing to comply with our September 10th order. That order was not responded to. On October 7th, we issued an order setting today's hearing. In it, we observed that neither Ms. Giassi nor Ms. Berger had responded to our September 10th or 23rd orders. We ordered each to file a notice with us that they had received this order. That is routinely done for fear that we have some type of an email error or a service error. On October 14th, which was timely based on how we compute the due date, Ms. Berger filed a response and a motion. She said she no longer worked for the firm and asked to be released. We relied on her factual representations and issued an order discharging the show cause as to her on October 18th. On October 15th, which was timely based on the due date, Ms. Giassi filed a notice of receipt saying only that she would appear at today's hearing. That was 34 days ago. So Ms. Giassi, I suppose my first question for you would be why, even if, and I was able to skim your response, although I confess, because of how late it was filed, I wasn't able to digest it fully. I understand that you have rationales for why you didn't respond to either of our court's orders, and certainly you're welcome to say what you'd like to say about that. I wondered why it took until 6:30 last night to offer any explanation at all when you had time on September 15th, 34 days ago, to file a notification that you'd received the notice of the hearing and that you would be attending.
Well, I think there's two explanations for that. One, I've never been in this situation before, so I looked at the order several times, and the purpose of my filing last night, I think, was more just to provide myself with an outline. I wasn't sure that there was a way to avoid having to appear, so I apologize for that misunderstanding. And then second, I touch on this in the response. I did communicate with Mr. Batar a few times, and it took me until mid-November to touch base with my client about the settlement offer that was on the table and find out whether or not he wanted to accept it. And that kind of played directly into, I guess, the delay in filing a response, because I wasn't sure if he was not going to accept the settlement offer, whether I was going to have to seek additional relief from the court in the form of an extension of the mediation, which would have likely been moot, or ask for time to file the initial brief or to prepare the initial brief. I don't know if that makes sense.
I won't answer the last part as to whether or not it makes sense. I think ultimately the panel will decide what if any sort of sanction is imposed as a result of the delay. I suppose what I struggle to understand is, if you knew that you were facing personal sanctions 34 days ago, why not offer the explanations that you offered in your filing of 6:30 last night on a more exigent time frame?
I
The
should have done.
the consequence of that is that we're having a hearing now, as opposed to you regularly appearing in our court, knowing how to file appellate documents, knowing how to put together a response. I You precluded the option of us not being here.
I understand that from what Your Honor is telling me, but I read the order just to ensure that everything was done timely. And I honestly have never been in this situation before, so I didn't realize there was a chance that I wouldn't have to appear, regardless of what I filed. I did not know that. I've never had an order to show cause issued
I
towards
mean,
me personally.
so I'll accept your answer at face value. The only thing that I would say to that is, did you notice and acknowledge that Ms. Berger had successfully moved to discharge the show cause hearing by filing a prompt response to our show
I
cause order?
Absolutely. And I spoke to her before she filed it, and we discussed whether or not, I wanted to file something jointly for her explaining all of this. And she said that, I just said, look, as long as you didn't need to move to withdraw, go ahead and explain that. And everything she represented to the court was true. She resigned in April and was no longer with the firm. So given the fact that she was in more of an associate capacity, I thought that what she filed was accurate and good faith and, did alleviate any confusion over her, involvement in the circumstances of this case, which was none. She was already not employed by the time the mediation was, set and then canceled.
Is there anything that you'd like to say in response to the show cause order?
Sure. No, I mean, everything that I put in the response, and again, I will start by saying I genuinely apologize for not filing it earlier. I acknowledge even in the response that, I read a lot of, and now, maybe some of what I read makes more sense that I should have filed it sooner, but, I even acknowledged in the response the time that it imposes on your honors and your staff to have to, um, set something like this up. So I will start by saying that I do apologize. I'm sorry. I take medication for makes me have a dry mouth, so I apologize. So I will start by saying that I should have filed something sooner. I did, not really resolve the underlying case until I want to say my client authorized me to accept the settlement on November 6th. I talked on the phone to Mr. Bitar just to keep him in the loop very shortly after that. So I apologize for communicating with him when I probably should have been preparing a response and filing it and communicating with the court. But I think he can tell you that I think we spoke at least once, if not twice, and maybe even yesterday about this scheduled appearance. So I do apologize for that. I just hope that I hope that the explanations provided somewhat put, everything in context. I do know that the mediation was not, um, my paralegal she got confused. We were working with a new law firm and sometimes she thought she was telling trial counsel that the mediation needed to be rescheduled because I was double booked and she didn't let counsel know. And then, when the settlement offer got extended on August 1st, uh, I truly thought that that was the best route for my client based on, discussions we had had prior to filing the appeal, and some updated information that I got about just, what, if anything, he stood to recover if I was to successfully obtain a reversal. So, um, I just, should have stayed on top of everything more closely. And obviously that starts with filing the response that I filed last night. Sometimes I file responses when they're not even required by courts just to outline my thoughts. So I think that that was more or less what I was attempting to do was just to put everything down and make sure that I reviewed everything and didn't make anything, not make a misrepresentation of any kind. So I do apologize for that. you know, I think if I could say anything, it's simply that I understand how it looks from where the court is sitting. Um, I think you know, the, behind the scenes, there certainly was, and, obviously I kept in touch with my client. I kept in touch with Mr. Bitar after, I'm conceitedly a overwhelmingly busy month. And, when Miss Hill, who is prepared to log on today, but I just didn't want to put her through that. She obviously signed the motion, when she called, and then just the hurricanes happened. All I can tell you is that the month of October was a blur. It was a blur of, hectic, overwhelming, just, it was a scary time to live in Tampa. It's the first time we had ever evacuated from Milton, um and then, I have a lot on my plate right now. And, one of the reasons that even though our power came back on, I think maybe the 14th or the 15th, I ended up flying back from Tallahassee, leaving my car there. And my son, who's in his first year of college, drove it down later just simply so I could continue to work. I couldn't find 4 hours in the day to drive home. My husband came home earlier in the week, even without power. I stayed because I had an evidentiary hearing set on Tuesday, and we were at my parents' house. So, I, I did keep in touch with Mr. Bitar and ensure that the settlement offer was still on the table. And once some of the chaos from, uh, we're a small team, and I wanted Miss Hill to have as much time as she needed. And she's obviously still, her son overdosed, and it's just been, she's worked with me. She worked with me when I was at Civic and Watson. So, I've known her, and I've known her son for, since 2018. And so I say that, we're just a small team. And, her absence was felt. I did the best that I could. And, one of the reasons that I attached the emails that I, circulated among our team was just to show the panel that I just didn't see the September 23rd order. I didn't. I think I was going through my emails, and, there's an appendix where I'm circulating deadlines. I tell April on, I think, the 20th, the day after her son passed away, that I'm going to try to keep a running list of everything so she doesn't have to dig through a mountain of emails when she gets back. I circulated an updated list on the 25th, and, had updates as to all sorts of things that had come in, and I didn't see it. So it was completely unintentional. I did think that she had filed the response on the 16th. And so I didn't know that there was anything that had gone so awful and, just gotten to this point until I heard from, uh, Erin I think I was en route to Tallahassee, on October 7th. So she called me to let me know. So I just, obviously, I'm sorry, and I'm sorry that I could have filed something earlier and didn't, and avoided the time for you all to prepare and appear this morning. And I don't know if the panel has any questions for me, but other than just telling you exactly what happened and how we got here, I, I just, I just am sorry.
Does the panel have any questions? All right, we'll take the matter under advisement, and we will issue an order shortly. Thank you, everybody, for attending.
Okay, quick fun fact before I tell you what happened. Florida was redistricted. Is that what the word would be? Year before last, I think, 2023. They shuffled everything around, made it really weird. Like District 5 is like a V, and District 6 goes from Mickey Mouse all the way down almost to the old people in Naples. Like, so weird. Anyways, I understand it was based on population, but there's some districts that are like the sixth district covers a lot of area from the coast all the way up into Orlando and things like that. So I just wanted to show you it. The districts aren't really lined up with the demographics of the state based on where they're located, like they are in a lot of states. But the fun fact was, Florida didn't have an appeals court until 1957. If something was appealed from a trial court level, it went straight to the Supreme Court. I did not know this. I thought that was pretty interesting. The District Court of Appeal of the state of Florida's 6th District. That's a mouthful. And this court issues opinions like days later. When I watch other appeals courts, it's 6 months later before you get a decision. This court rocks it. I kind of want to go sit in there one day. Okay, sorry. On September 23rd, 2024, this court issued an order to show cause in writing within 5 days why sanctions should not be imposed against attorney Melissa Giassi for her failure to comply with our order dated September 10th, 2024, which ordered attorney Giassi as counsel for the appellant to address the appellee's allegations concerning mediation scheduling. She didn't respond. The court scheduled a hearing for show cause, observing that she had not responded to our orders dated September 10th, September 23rd. The evening before the hearing, she decided to file something because we all turn in our homework, the night after it's due. Attorney Giassi's written response and answers during the hearing do not provide a satisfactory explanation to the court's show cause order. Even if Attorney Giassi's asserted reasons for failing to comply with our order were justifiable, there is no acceptable basis for waiting 5 weeks and until the evening before the show cause hearing to first share facts of which she has been long aware. The parties' settlement of the underlying case does not excuse counsel's continued responsibility to comply with court orders. Based on this conduct, this court will sanction Attorney Giassi, directing her to pay $400 to the clerk of courts within 10 days. The clerk is directed to deliver a copy of this order to the Florida Bar and take any action necessary. Reflecting back, had she gone in and said, dude, I messed up big time. Short explanation, but I'm going to do this, this, and this to make sure this never happens again. She probably would have gotten away without major sanctions. But that's just me. That's just my mindset. I don't know. So on your way out, punch that like button. Hit subscribe if you haven't done so already because, more of me talking. Yay. And leave a comment that says #MegsBack. I'm going to do lots of drawings. We already have lots of winners. Huge congratulations to November Rain, to Stevie, to the Tooth Guy. I can't remember the whole username. To Camping Mom. I can't remember who else won, but editing Meg will pick that up and put something on the screen. Ooh, right there. Right there. Oh, right there. I don't know. Okay, it's been a long day. Everybody have a wonderful evening, and I will see you soon.